Okay, looks like we are ready to begin. Good morning, everyone, and thank you for joining part 2 of the Junior Property Professional webinar series. This morning, myself and Kaylee will be looking at changes implemented during lockdown into our day-to-day real estate practices and what changes will remain moving forward. We will cover the impact of coronavirus-related delays on property agreements, force majeure, lease requirements from each of the landlord and tenant perspectives which have arisen as a result of lockdown, and practical issues during lockdown, such as document signing, completion, and land registry requirements. Please feel free to raise any questions during the presentation using the Q&A button at the bottom of your screen. We hope to have time to answer questions at the end of the seminar, but if time escapes us, we will come back to your queries individually after the presentation. So we'll begin with coronavirus delay clauses. In an unconditional sale agreement or an agreement for lease, a coronavirus delay clause will primarily stand for the benefit of the buyer or tenant. So if a buyer or tenant that you are acting for would like the benefit of a coronavirus delay clause, we advise that the principles discussed during negotiation of the heads of terms. There are some agreements which are conditional upon planning permission or works being carried out to the property before completion. And in those instances, a coronavirus delay clause may in fact benefit both parties. Again, the principle of including a coronavirus delay clause should be agreed at the heads of terms stage, and the solicitors will seek to agree the precise wording during the negotiation of the agreement itself. So we'll begin with what do we mean by a coronavirus delay clause. The clauses themselves are slightly long-winded, so the purpose of this presentation this morning is really to take you through sort of an overview of the mechanics and the designed impact. The first point to consider, as you'll see on the screen, is what we mean by a coronavirus delay. And the first point is to consider the definition of a coronavirus event. Now, it is possible for both the landowner and the buyer or tenant to the agreement to be affected by different coronavirus events at the same time. But as we move into sort of the partial lockdown and the lifting of restrictions, it may be that one party is affected when the other is not. And the drafting to go into the agreement needs to reflect all possibilities. So as you'll see on the screen, typical examples of a coronavirus event which can impact performance of the obligations under agreement can include anticipated absences or availability of staff at solicitors or banks, thereby making it difficult in terms of the pure completion mechanics around circulating documents for signature, having monies in place, and actually dealing with the completion between the solicitors themselves. Illnesses, quarantining or self-isolation of the buyer, the landowner, their key signatories, and including any decision whether to quarantine or self-isolate, just purely in line with recommended coronavirus regulations in force at the time, can also delay the completion requirements. There can be delays as a result of disruption or interruption to services such as bank transfers, DX or post. Where they've got conditional contracts, any disruption or interruption to services of the local authority or public bodies from whom consent is required may also impact timing. Anticipated absences or the unavailability of any consultants to carry out practical matters at the property, such as inspections, reports, testing, can also impact obligations. There may also be a lack of essential service providers to the buyer or tenant, such as shop fitters to do the internal fit out, removal companies to simply get them in the premises, or utility connections being unable to be installed in time. There can also be practical matters for us as solicitors as well. Any delays in carrying out pre-completion searches and obtaining results because search providers are not available during lockdown can also impact the buyer's ability to complete. So once we have our list of coronavirus events within the agreement, what happens if one of those coronavirus events occurs? Now, in an unconditional agreement, it will typically relate to a straightforward sale or lease of land without any preconditions being required by either party. Therefore, the coronavirus event will typically only delay the completion mechanics. Now, the position that we've seen being typically adopted is that the party who is affected by the coronavirus event should serve a notice on the other party relevant to the transaction, explaining what the event that has occurred is. Once that event is no longer existing, then they should serve a cessation notice as soon as reasonably practicable to the other party, which then advises the other party that they are now ready to complete. And completion will take place within agreed number of working days after that cessation notice has been served. It's worthwhile considering long stop dates, even in unconditional contracts at the moment. So if completion does not take place by the agreed long stop date, the party who is waiting for the affected party to bring themselves in a position ready to proceed can terminate the agreement in writing to the other. The long stop date is also open to agreement between the parties to the contract. Conditional property contracts already have various long stop dates, by which time specific conditions need to be satisfied. In certain circumstances, additional drafting is required to extend those long stop dates in order to try and avoid a termination resulting from the lockdown restrictions. Coronavirus events, as you've seen from the previous slide, can include impact on third parties who are not directly linked to the contract itself. A typical example would be a building contractor or any of the professional team who are carrying out works to the property. The definition of coronavirus event does need to be considered carefully. Some events will only be applicable before the current agreement becomes unconditional. Some may arise after the agreement becomes unconditional but before completion takes place. Or some may impact any of the obligations at any time under the agreement, including post-completion matters. Generally speaking, a more expansive definition can be narrowly construed, so therefore any specific concerns which may arise out of a future lockdown should be included in the definition of coronavirus events. Now, whether you're dealing with an unconditional or conditional property contract, the drafting puts the affected party in the position of proving the existence of the relevant coronavirus event. If there's any dispute by the party receiving the notice, they can either just seek to agree the terms of the notice or refer the matter for third-party determination. Typically, we'd expect expert determination to be more appropriate rather than full arbitration, but this will be dependent on the circumstances relevant to the parties and the nature of the agreement. Many conditional agreements for sale or agreements for lease will cross-refer to construction contract force majeure provisions, where works are being carried out to the property before completion is required. Now, great care must be taken when incorporating additional force majeure clauses in either contract, as there is a risk of conflict between the two agreements. Our colleagues from our construction department, Gwilym Evans and Chris Lamb, will look at this further in our third seminar of the series in 2 weeks' time on the 31st of July. So in short, which of these changes around coronavirus delay clauses will stay? Whilst coronavirus remains a threat in the UK and probably globally, we consider that the clause will be ideal or sought by either party. As lockdown eases and restrictions begin to lift, the requirement may start to ease as well. Now, some of you may also be wondering about the availability of force majeure, and Kaylee will explore this in the next few slides.
Thank you, Jo. At the beginning of lockdown, we received a large number of inquiries revolving around how parties to agreements and leases could avoid paying rents or delay completions. Many of these focused on whether a force majeure clause could assist them in excusing the parties from performing their obligations or from doing so on time. So in order to answer this, we need to consider what is a force majeure clause. Force majeure clauses are contractual clauses which alter parties' obligations and/or liabilities under a contract when an extraordinary event or circumstances beyond the control of the parties prevents either party from fulfilling those obligations on time or at all. Under English law, these clauses are contractual in nature. This means they must be included in the documentation and do not arise by way of common law or presumption. Force majeure clauses have a variety of consequences. They may excuse either party from performing the contract in whole or in part. They may allow the parties to delay completion or performance within the timeframes expected under the original agreement. Or, in extreme circumstances, they may allow a party to terminate the agreement altogether. So where can these be found? In commercial real estate, force majeure clauses are mainly found within agreements for sale, agreements for leases, and development agreements. They are rarely found within leases. However, we will look at options for leaseholders later in this webinar. So let's look at a typical force majeure clause. There are three standard types. The first, which lists out specific events, such as in option A, which you can see on your screen. The second covers a much wider spectrum of beyond reasonable foreseeable events, which I will show you in a moment. Then there's a third option, which amalgamates both of these by including an open-ended list as well as an unforeseeable events statement. The key issue when looking at these clauses in the current climate is clearly whether COVID-19 and its events can be covered. If we start by looking at option A, there is no mention of a pandemic or epidemic. At bullet point 4, we can, however, see that this makes reference to an act of government. This can be somewhat helpful in respect of COVID, where certain closures or restrictions are imposed by law. For example, in the retail sector, the COVID restrictions prohibited some shops from opening. However, this is not so helpful where the government have only issued guidance and not strict prohibitions. For example, in the construction industry, construction was not prohibited, but there was strict guidance imposed, which made some sites impossible to run. As option A is a conclusive list, it will be difficult to argue that the wider effects of COVID are included, and therefore it is unlikely to help a party wishing to rely on it. Now, if we look at option B, this is a much broader and has no specific list of events. The clause stipulates that the event must be beyond the reasonable control of the parties, and that they could not foresee it or avoid it. Assessing whether COVID-19 is covered by this open clause is very much fact-specific and could be interpreted in many ways. Unfortunately, at this stage, we have no case law to either support or reject the possibility that these clauses cover pandemic situations. However, given the unprecedented nature of the COVID-19 pandemic, it is likely that a court would look favourably on a broadly drafted clause. Therefore, it is likely that COVID-19 would constitute a force majeure event under this clause. For parties seeking to rely on force majeure provisions, proving that COVID-19 is covered by the drafting is only the first hurdle. The party must also prove that not only has the event taken place, but that it directly affected performance of the contract. Where a party is trying to delay completion, this may be easier to prove. However, where a party wishes to terminate an agreement, this may be harder, as they would have to prove that the events of the pandemic have made the contract impossible to perform. Over the coming months, it is likely that a number of cases will deal with and look at force majeure, and whether these can be applied to the current pandemic situation. However, it is interesting at the moment to consider whether, looking forward, the force majeure clauses will change permanently. Many agreements now being drafted are including COVID-19 wording, as Joe previously discussed. Although a positive move forward, many landlords have been reluctant to agree to widening these clauses to cover future pandemics or epidemics. So although parties entering into contracts now may benefit from COVID-19 wording, it does not appear that anyone is willing to cover the risks caused by a future pandemic event, and therefore it does not look like these clauses will be permanently changed. However, case law in the coming times will likely provide greater clarity on this. Joe will now have a look at occupational leases and the issues that both tenants and landlords have had to consider in this difficult time. Joe, I think you're muted there.
Thanks, Kaylee. As explained in the previous slide, Kaylee very well explained, very few leases contain a force majeure clause which allow either party to suspend the obligations under those leases. So the tenant's obligations, most predominantly to pay rent for a property which it cannot use, do still continue, as do a landlord's obligation to provide services despite being unable to access buildings or perhaps having the service providers available to them. Firstly, the slide shows, we can just change the slides, thank you. If we look at the slide shown on the screen now, this shows several tenant considerations around rent payments. This is the most dominant obligation on tenants. Some leases, or many leases, will contain an obligation for rent suspension or rent reduction where the damage or destruction of the premises is caused by an insured risk or possibly even an uninsured risk. But as coronavirus does not itself cause physical damage or destruction to any of the premises, these provisions are not available to tenants. So to assist with cash flow during lockdown, we have seen a significant increase in tenants seeking rent reductions or concessions or changes to the frequency of their rent payments. There are no obligations on landlords to accept these concessions or temporary variations, but there is an advantage to landlords in trying to help the tenant maintain its cash flow, continue its business, so they can continue with the lease and the property income under the rent payments once the lockdown restrictions have eased, in order to try and ensure the long-term future of the tenant, their occupation, which is ultimately beneficial for the landlord's investment. Landlords have the option to defer, reduce, or entirely suspend rent for a period in order to assist a tenant in avoiding insolvency. Of course, the landlord does need to bear in mind the impact of rent concessions on their own cash flow and business needs as well. In particular, landlords receiving turnover rents in retail leases have been significantly impacted, where premises have been forced to close for lockdown or may even be permanently closed as a result. Any decision around rent concessions must be documented very carefully, and Kaylee will explore these options in the next slide. Other obligations away from monetary payments are also now being raised more frequently. Tenants are seeking to remove or escape liability under leases where lockdown prevents the premises from being used at all. This is a high bar for a landlord to accept, and to date there appears to be understandable resistance from landlords on this point. Unlike tenants, landlords have little or arguably no protection from the government during lockdown, so they are reluctant to make further concessions on other tenant obligations. The landlord's obligations in the leases also need to be considered. The most typical obligation is an obligation to provide services. Well-drafted leases will include exclusions in respect of matters which are outside the landlord's control. It may be that the landlord's obligation to use reasonable endeavours to provide the services means that if the coronavirus makes it impossible to provide those services using reasonable endeavours, the landlord would not be liable for its failure in that obligation. Provision of services can take into account restrictions or requirements of social distancing under the Coronavirus Act 2020 and guidance from Public Health England. There may also be an obligation to provide deep cleaning of the building in which the premises is situated. The deep cleaning wouldn't relate to the demised premises itself. This would be an obligation on the tenant, but it may apply to any common areas within the building. There may also be an obligation to set out sufficient social distancing measures in those common areas as well. So the question as to whether the landlord can recover those additional costs as new services will depend on the wording of the lease. There are often provisions to cover costs involved with good estate management or other reasonable measures at the landlord's own discretion, which may well extend to deep cleaning requirements and other protective measures needed under the coronavirus regulations. This would mean that the associated costs of these measures can be recovered from tenants as well. So will these changes stay? None of the landlord's considerations are particularly new practice, but their importance has been highlighted over recent months with the viewpoint of preserving the investment value in the long term. Consider any temporary rent concession or reduction to be a short-term pain for the long-term benefit of keeping the tenants in place and having the rental income into the future. For tenants, whilst COVID-19 remains a threat, they will continue to seek as much comfort as possible. The final position agreed between the parties will ultimately come down to their respective commercial positions. Kaylee will now take you through the options of documenting any agreed changes to occupational leases.
Thank you, Jo. As Jo noted, as a tenant under a lease, you will be obliged to continue to pay your rents even when running your business from your leased premises is not possible. You will need to continue to comply with all your obligations, and this will include having to make payments of service charges and insurance rents. Last week, my colleagues Stephanie White and Naomi Campbell discussed the current position in respect to taking back a property if a tenant does not pay its rent or becomes insolvent. But what steps can landlords and tenants make to avoid that situation? As a starting point, as Jo discussed, any changes to your lease or waiver to a rent payment must be agreed between the tenant and landlord. Although these do not need to be formally documented, we would always advise that they are, as this will assist in any disputes at a later stage and also provide clarity for both parties. I will now look at the various arrangements we've seen over the last few months, which have assisted parties and the advantages and disadvantages of both. The main option we are seeing is parties entering into side letters. Side letters are usually confidential arrangements between the parties. These are usually temporary in nature and cannot usually be registered at the land registry. This is beneficial to the landlord, as other tenants will be unable to see the deals being made behind closed doors. The letters are usually very quick and easy documents to put together, so it decreases any legal fees or delays being incurred. They can usually be terminated with little to no notice, which is beneficial for a landlord, as this gives them flexibility to terminate the arrangement in the future as the market develops. Side letters most commonly have changed rent payments from quarterly to monthly, waived or reduced tenants' rent payments, or delayed payment of rent to a later date. These do not vary the original lease itself and will usually not benefit an assignee. An alternative, more permanent approach to a side letter is to enter into a deed of variation. This acts by formally varying the terms of the original lease. These are usually where the parties have come to a longer term arrangement. For example, where a tenant has agreed to remove a break right in a lease in exchange for a current rent-free period. This would most usually be documented by a variation. These are often registrable at the land registry and are usually more complex, therefore often take longer to agree. However, the benefit to the tenant is that they cannot usually be terminated without agreement, giving both parties greater certainty and often a mutual benefit. Another option we are seeing is the inclusion in some leases of COVID-19 rent abatement clauses. Although these are probably the most controversial, with landlords pushing back quite heavily. These are clauses included within the lease itself, which in effect cover a further lockdown period. These are mainly being negotiated into new leases as opposed to varying current leases. These benefit the tenant as they alleviate the risk of a second lockdown, whilst also helping landlords get reluctant tenants to sign up for leases now, whilst we are still in a state of unknown. As these form part of the lease itself, these are usually registrable at the land registry and therefore publicly viewable by the tenants, which can often discourage a landlord. An alternative to an abatement clause within the lease itself that we have also seen is the emergence of COVID-19 rent repayment deeds or COVID-19 indemnity deeds. These are deeds whereby the landlord agrees that in the event of a further lockdown, they will indemnify and repay the tenant any rent paid which covers that period. As with the COVID lease clauses, these alleviate the risk to tenants of having to pay rent in a further closure period, and also help landlords secure new tenancies. These are usually confidential and personal to the entities that are giving them. This can assist where landlords are reluctant to amend a lease permanently. However, the tenant wants greater comfort for future events. These can be beneficial to landlords who are also concerned about the investment value of their property, as these agreements are usually non-assignable and therefore a future landlord would not be bound. The final option for a tenant who wishes to vacate a property and terminate all future liability is the surrender of their lease. As with the previous option, this must be agreed by the landlord, and often landlords are unwilling to agree to a surrender without a premium being paid. This can be an option for a tenant who wants the certainty in the future of not being bound by their lease and the underlying rent payments, and can benefit a landlord from having to pursue a tenant who has gone into insolvency. The purpose of all these options is to help parties work together to alleviate the risks and issues that have been caused by COVID-19, And as time progresses, these solutions will hopefully be less needed. As with force majeure clauses, landlords are still reluctant to agree to terms which extend beyond the current pandemic situation. However, moving forward, tenants are likely to be pushing for more flexible lease terms at the heads of term stage. Landlords currently have the upper hand as tenants are bound to comply with their existing lease obligations. However, as the world opens up, it will be interesting to see who holds the upper hand in negotiations, particularly where workforces are likely to move to home working and retail spaces may be less desirable. We will now give you a brief overview of the practical issues that we have faced in commercial real estate transactions during the last few months and whether any of these changes will stay.
So firstly, looking at statutory declarations, the Landlord and Tenant Act 1954 contains a statutory security of tenure right for tenant under commercial leases. Where the lease is to be granted outside of the security tenure provisions, a statutory declaration is typically sworn by the tenant in front of an independent solicitor to acknowledge the exclusion of the security of tenure right. Access to an independent solicitor during lockdown has been difficult for most tenants unless they have a family member who is a solicitor and separate to the transaction, or their solicitor equally has access to an independent solicitor. Thankfully, the LTA 1954 provides a process for simple declarations, which do not require a declaration in front of an independent solicitor. However, the caveat with the simple declaration process is that there must be a 2-week delay between the landlord serving the Landlord and Tenant Act notice and lease completion to account for the lack of formal statutory declaration in front of the solicitor. As we move out of lockdown, we consider that the favoured practice of statutory declarations will resume again in order to speed up the timing to completion of the lease. Statutory declarations for title matters. Sometimes property contracts may require a statutory declaration around a title defect, but these statutory declarations can only be completed or sworn by the declarant themselves. Clearly, such swearing has been problematic during lockdown, but again, normal practice will resume as lockdown restrictions continue to ease.
Signing. During COVID, we've seen a push towards electronic signatures due to the difficulties of postage, self-isolation, and the ability to print documentation from people's homes. However, in property, the use of electronic signatures is still rare. Under the Land Registration Rules 2003 and the Law of Property and Miscellaneous Provisions Act 1989, any document which affects a disposition of land, such as a lease, transfer, or charge, is required to have a wet ink signature. This has been a harder requirement to fulfill during lockdown. Although the Land Registry have not removed this requirement for a wet ink signature, it has temporarily allowed a change to registration and completion requirements. In practice, this means that solicitors are able to complete on scans of a wet ink signature page when certain requirements are met. A party entering into a deed will therefore be able to print, sign, and scan the signature page only, and it's been confirmed that even a photo of that page would be acceptable, making this much easier to deal with practically. I think in the digital age, it is likely that these changes will in time be made more permanent, particularly in light of an increasingly global nature of transactions and the now at-home workforce. Although historically there has been a reluctance to make any changes, the pandemic has pushed this issue into light, and yesterday, the Land Registry published news that it will, following a consultation process, be implementing the use of electronic signatures. This is great news in the property industry, and although the details of how and when this will be implemented are yet to be confirmed, this shows that the current situation has encouraged change within the views across the market. Going hand in hand with the issue of signing has been the availability of witnesses and the process of witnessing signatures. Under the Companies Act 2006, a deed executed by a company must be signed by 2 directors, 1 director and a company secretary, or 1 director which is witnessed. Likewise, under the Law of Property Act 1989, an individual signing a deed also requires their signature to be witnessed. Solicitors will often ask for witnesses to be independent. However, there is no statutory provision requiring this. Neither the Law of Property Act or the Companies Act prevent a signatory's spouse, civil partner, cohabitee or family member from acting as a witness, provided that they themselves are not a party to or benefit under that deed. There is also no prohibition on a minor acting as a witness, but as always, it is advisable that the witness be aged 18 or over. The purpose of having a witness is so that at a later stage, the parties can provide unbiased evidence that the document was properly executed. And where the witness is not independent, this can be called into question. It is therefore best practice for the witness to be independent of the signatory. This poses a significant challenge if a signatory is self-isolating. Unfortunately, video witnessing is also not a viable option. During lockdown, the use of video witnessing was raised. However, the Law Commission concluded that witnessing formalities require the witness to be physically present in the same location as the signatory, and therefore technology has not assisted us. Over the course of lockdown, we have seen various processes taken in relation to witnesses. Witnessing has often taken place by family members. Although not ideal, it's often the only possibility. Witnessing from a distance or through a window has also been used. We have also seen shop assistants, cleaners, and even doctors witnessing documentation. As lockdown eases and people return to the workplace, these issues will hopefully be lessened. However, it's likely that in the future there will be changes made in order to accommodate the current climate and changing practices across the market. There have also been various changes to assist with this made by the Land Registry, which Jo will now discuss.
So turning to land registration issues, as a result of the challenges of lockdown, as Kaylee just mentioned, the Land Registry have also introduced some temporary changes to their accepted practices. The principle of the Mercury guidelines was outlined by Kaylee previously in that the transfer or other dispositionary documents can be signed with wet ink signatures by both the signatory and the witness, a copy of the signed page taken by the scan or photograph and emailed to the solicitor. The solicitor is then permitted to use the signed page as a single composite document, complete that document with the other party, and then submit that document to the Land Registry for registration. To assist with requisitions raised to Land Registry applications, cancellation dates have been extended until further notice. Any new requisitions that have arisen during lockdown do not display any cancellation date. Once it is appropriate to resume normal service at the Land Registry, they will resume sending warnings of cancellation and typically give solicitors 4 weeks to reply to a requisition before an application will be cancelled. Additionally, Land Registry requirements for verifying the identity of unrepresented parties to a dispositionary document have also been relaxed. From the 4th of May, verification of identity procedures have been extended to other professions of people who can verify identity, and also allow verification to be carried out by video call where certain conditions are met. Now, all changes by the Land Registry are strictly temporary, and we await hearing when the normal stricter practices will come back into effect.
So now to the future. In the increasingly digital age, where it's likely more people will be home-based, many of these solutions are likely to stay in place and be formalised. The Land Registry have been reluctant to change, but over the coming months, it is likely that some of the temporary changes we've discussed will be made permanent as we see new guidelines and protocols for virtual signings and completions. There is a definitive engagement across the industry to adapt to the COVID-19 pandemic. However, there is still a reluctance to agree to permanent changes around any future events. Landlords and sellers across the board have tried to work with tenants and buyers in order to find a middle ground and a successful outcome for both parties. However, when it comes to the future, there is an unwillingness to cement these changes in the long term. Thank you for listening to our webinar, and we now open up the floor for any questions.
Thanks, Kaylee. We've had a couple of questions through during the course of the presentation, so thank you for those. Slightly conscious of time, but I did want to pick up the first question that came in during my discussion around the coronavirus delay clauses. And the question was around or concerning works under a sale agreement and the position where the provisions of the property contract and the building contract in relation to coronavirus delays and force majeure are not the same, who would be liable? Well, in short, any gap to these provisions would fall on the landowner, who is responsible for ensuring that the property agreement with their buyer or tenant does marry up with their contract with the building contractor. The seller doesn't want to lose their buyer or tenant as a result of failing to comply with the works requirements before the long stop date within the property agreement. So therefore, the importance is clear. Now, as I mentioned earlier in the presentation, this links very nicely with our part 3 of this webinar series, which is taking place in 2 weeks' time. Our construction colleagues, Gwilym Evans and Chris Lamb, will be looking into time works within construction contracts and issues which have arisen during lockdown. So please sign up to the webinar using the details on our website. In the meantime, we are now out of time. And on this basis, both Kaylee and I would like to thank you for joining us this morning. Our details are on the screen now. If we can just have a quick change of slide. Thank you. So if you have any further questions or would like to provide us with any feedback on this morning's presentation, please do get in contact with either of us. All the other questions which we've received during the course of the presentation, we will come back to you directly on. But again, thank you for your time this morning, and we look forward to having you join us again in 2 weeks' time.
Thank you very much.